Greetings, loved ones. Welcome to another episode of Divergence Live, also known as the Wisdom System, brought to you by myself and all our other lovely queens here today. I'm going to turn this over right away to Ravina, one of our esteemed queens, and she's going to fill you in with some housekeeping details that we need to be aware of and keep in mind at all times. Thank you, everybody. Go ahead, Ravina.
Thank you, Darren. Welcome, everyone. Please make sure your cameras are on at all times, that there is enough light for us to be able to see your full face. And the full face, it's only part of the body that we like to see. So if you are taking notes and the cameras moves away, please make sure it's pointed out to your face again. Thank you for your collaboration. I'll pass it to you, Darren.
Okay, thanks, Ravina. All right, so, episode 6. What we're going to be talking about here is something called the averment of jurisdiction. Before I tear this one open, I would like to touch on a little subject that one of our loved ones is experiencing right now. This was just brought to my attention while I was in the shower about 15 minutes ago. Gentleman here has experienced something where the bank has now frozen his accounts. He doesn't have access to it. Why is this happening? This is happening because the banks are actually acting in proper due diligence. They are actually protecting certain accounts, certain users, certain things from happening. This is a protective measure. This is probably the 5th time that we've run into this. I've had a couple other loved ones that got scared, they panicked, they bailed, they hit the eject button, they sent a few letters to the bank managers, care of, legal department, yada, yada, yada. Please remove the hold from my account, et cetera, et cetera, et cetera, et cetera. But I'm just going to encourage this loved one just to hang on for a little bit, because what this is doing is this is actually a blessing in disguise. Your Honor, it's apparent. Here's the proof. The banks have shut down everything. I am destitute because I have expressed an equitable interest in these accounts. I have actually subrogated my position. I've done some stuff. And this is why I need the immediate, urgent aid and assistance of a court of competent jurisdiction to remedy this situation. And again, that, although it's not life-threatening, it's pretty freaking close to life-threatening. If you can't pay for milk to put in your fridge, if you can't, pay for medications, et cetera, et cetera, et cetera, et cetera, equity will not allow us to be left dangling merely because we start expressing an interest in our proper capacity here. So this actually invokes the court to get the ball rolling and get some aid and relief granted to you. This is the segue to why I'm actually laying out why the bill in Chancery, the original bill, or why the petition brought to Chambers without notice, on short notice, ex parte, et cetera, et cetera. This is why this bill, this is why these things, these particulars that I'm going over here every day are so important. We actually should have this all dialed in, set up, ready to go before we start firing off notices and stuff to banks, creditors, federal tax collectors, things of this nature. So this gentleman is not in a predicament like he may have initially thought. This is where we will actually expedite his process in the matter of the next couple of days or over the course of the weekend here, and get this presentable to a judge so that he can actually have the relief that he's praying for. Again, some of the reliefs that we're praying for are: vest that legal interest in new trustees, please. Provide the accounting for me, please. Provide the injunction. Get me the personal representative so that I don't have to deal with this shit anymore. This is all part of we just had a tornado go through the trailer. This is part of the reason why we're doing all this, loved ones. This is to be taken seriously. And again, this needs to be dealt with in a manner that I can explain it. Although it's technical and it's hard to read, I'm doing the best I can to soften this or get it to your brain in a manner in which you can start to digest it. That is ultimately the most important thing to do here, because if I just give you the blame, again, as I've mentioned before, if I just give you the document and you go fire it off to the judge, chances are you might fall on your face with the very first question the judge asks you. How do I know this? Because this has happened to us before, not me specifically, but other loved ones. Okay, what's the remedy you're seeking? Oh, well, I don't know. Well, how do you wish to proceed? Well, I don't know. So again, we actually have to be a little bit, what would the word be? We need to actually have our ourselves dialed. We need to have a little bit of a grasp or an understanding of what the hell is going on. Because again, we've had a number of loved ones go before the judge where they were this close to pulling it off, but then the ball gets dropped. I don't want to put any of us through that situation. Why? It's morally defeating. It makes you feel about this big. After spending all this effort, now all of a sudden I got there, I got to the door, knock, knock, they opened it, and then I tripped and fell down. We need to be doing a better job. I need to be doing a better job of preparing. And again, this isn't just me. Again, I shouldn't take credit for this. Many loved ones, many individuals, women and men out there are pursuing this journey. I'm going to say there's probably more than millions of people doing this globally. There's a lot, right? This is quite the thing going around right now. This is what's ushering in the new era for man, womankind. So without further ado, we're going to get into part 6. Again, this is called the averments of jurisdiction. And why this is important is this. If you don't roll in and clearly establish what jurisdiction it is you're seeking, guess what jurisdiction you're in by default? Any guesses? Common law, legal, at law, military. So we actually have to come in and say, hey, court, hey, Your Honor, I'm here seeking equity and doing equity. I have established, or I'm calling on the court, a court of conscience, a court of good reason, to fulfill all the things that I am seeking here. Again, can you imagine going to Caesar saying, hey, slave master, I no longer wish to be a slave? What do you think slave master says? He says, beat it. Get back out in the field. Go pick your cotton. Go do whatever it is you were doing. You're not entitled to even ask me to be relieved of duty unless what? I've actually heard stories where the slaves could buy their way out. They could purchase their freedoms back. Kind of coincides with what we're doing here by attaching valuable consideration and or silver coin to some of our paperwork and our expressions here. So without further ado, averment means an affirmation or allegation. That's all it's saying. I allege that the jurisdiction of this proceeding is equity. If you don't establish that, if you dismiss that or don't give that any regard, guess what happens? The court by default keeps you stuck in Caesar's world. We don't want to be there. It's not as fun as we used to think it was. Okay, so a formal statement by a party in a case of a fact or circumstance which the party offers to prove or substantiate. Why are you entitled to an equitable jurisdiction? I would put that pretty close in our pleadings to the front end of our documents. I'm entitled to the following because I've done this, that, and the other. And I know that this, and this will be the result. That's literally all we got to say. This is where the clerks are, they're going over our paperwork and they're looking for criteria. They're testing our paperwork to see if it can stand. If it can't stand in chancery, although they don't call it that anymore, call it a court of inherent jurisdiction or a court of equity, or on the other side of the court, okay? Because again, it's presumed that we're on the legal side. That's one side of the ledger. What would the other side be? Well, by default, it has to be equity. So we can literally imply that it's equity by just merely suggesting on the other side of the court, the non-public side. So the 6th part of your bill or your petition is called the averment of jurisdiction, the allegation of the jurisdiction that I'm bringing to you, Your Honor, and is commonly in the particular words as follows, or to a similar effect. Here we go. All which actings, doings, refusals, and pretenses are contrary to equity and good conscience, and tend to manifest wrong and injury in your petitioner. That right there, that opening sentence is it's loaded. Here's why. We're suggesting that, hey, Attorney General, if you refuse to do the following, which you're gonna, because we know. Hey, Minister of Finance, if you refuse the following, if you deny the following, if your pretenses are such that I need to prove I'm entitled, well, put your seatbelts on because here it comes. I'm entitled to equity because I am injured. I suffer wrongdoing at my own hands. My own dirty hands put me in this situation. And I require, again, require is an important word. I request, I desire to be relieved of that obligation, Your Honor, on the following, evidences that I'm going to bring before this honorable court. Why? Because I am remediless at law. the strict rules of the common law and cannot have adequate relief save in a court of equity, where matters of this and like nature are properly cognizable and relievable. That opening paragraph sets the jurisdiction. It says, hey, I can't have the relief I'm after at law. Again, hey, Caesar, let me go from this Caesar salad. He's like, no, crouton, get back in the bowl. You know, you don't have the right to jump out of what you've already obligated yourself to do unless you do it properly. Dean and I used to jump up and down and scream bloody murder that, oh, this isn't fair. This is bullshit. Blah, blah, blah. You know, are those proper facts that the court is actually going to give cognizance to? No. You got to actually bring in a little bit more substance than that. You got to articulate these words with a little bit more fashion, with a little bit more skill. And this, again, this is the entire reason why these live episodes are getting put out daily now, because there is a lot to this. Out of all the parts to create a proper bill in equity, or an original bill in equity, or your petition property, there's approximately 10 parts. One is kind of like, well, a little loosey-goosey. We don't have to bring it because we can imply that it has already happened. But that's one out of about the 10 that we need to go over, and we're at 6 right now. And as such, after we go over the entire 10, we'll just loosely go over them one more quick time, and that's when I will actually disclose some of these working documents that we're working on. This way, so now you can see why I'm actually preemptively saving myself a whole bunch of grief by explaining all these things beforehand, so that when the document shows up, I don't have a million hands go up and then spend the next 2 weeks describing it all. We're doing it right here. The averment alone will not give jurisdiction to the court unless a case be shown in the bill or petition from which it is apparent means it appears. So once it appears that the jurisdiction properly belongs to it, therefore the omission or not including this clause will not render the bill or petition defective. Okay, so what that is saying is you don't have to put this clause in if the rest of the petition or bill is substantive enough to tell the clerk, the judge, the master, whoever's looking at it, that, hey, there's enough proper pleadings in here that we actually didn't have to establish that we're in equity because the pleadings actually do it itself. But you know what? Check this out. It seems to be clearly advantageous when the clause and the words are used in the following manner. The complainant charges and avers that equity needs to be here because the said defendant is possessed of a considerable estate. How is he possessed of a considerable estate? Ooh, again, there's one of those magic words, considerable. Possessed. He is in possession of an estate that has valuable consideration attached to it. When he became the security on the said note or certificate by appointment, conveyance, or assignment. Hey, Your Honor, I'm no longer in possession of this thing. I've made it incredibly valuable, and I've placed it into the hands of a party believed or known to be capable of dealing with it. Loved ones, are we capable of dealing with this stuff? I'm going to say no. I've been doing this a long time, and I'm barely capable of dealing with this stuff. I don't want to act as trustee a whole lot, right? That would be most people's contention. I don't want to act as a trustee for my neighbor just because my neighbor doesn't know how to do this stuff. That's where divergence comes in. That's where I come in. This is where the queens and the other loved ones come in, is that we're actually offering to act as trustees temporarily as administrators to help you deal with your situation. Because here's why. Hey, Attorney General, I need you to act as the administrator of this express private trust. He picks it up and says, okay, thanks. And then all of a sudden, your bank account has $100,000 dropped into it every month. Where's your level of knowledge? How are you going to go forward now and help others? If it's your intent to be on these Zoom meetings for yourself and not to go out and go forth and help others, I'm not going to deny you that privilege or that right. What I'm suggesting here is that we as teachers should embrace, or should at least consider, the option of going forward and helping others. Isn't that the basic fundamental definition of acting charitably? put yourself in a position where you have the knowledge, you have the wisdom, you have the ability to go help a neighbor who's in distress. Having the knowledge of having to do this is way more valuable to me than having the 100 grand show up in my account every month. I actually don't give a shit about that. And I'm just going to keep saying that over and over and over and over again, because I'm going to do everything I can to put as many others through, at least at the same time as I go through. There's proof of a selfless act. I know of a few people, I haven't met them personally firsthand, but again, these are stories coming from other loved ones that I do respect and admire. They have had students that have actually gone through the gates here, and then they go poof, they disappear. I have yet to see evidence of, miracles happening here on this planet. I don't see poverty being solved. I don't see, anything of this nature coming down anytime soon, except for the Nasera and Jisera. Okay, these things have been around for several years now. I'm going to throw it out there that everyone on this panel tonight has an idea what Nasera and Jisera is, what it's meant to do, how it's going to be put into the hands of the people, this, that, and the other. Well, again, as private citizens, as private nationals, we're actually going to have a say. We're actually going to have an input. We're going to actually have the ability to help direct the outlay of the Nasera Jisera program. That's rolling out regardless. However, I would love for us to have our input, because I see how much of how they conducted themselves in the past. And although the white hats or the good guys are allegedly in control now, and we're about to remove a whole layer of filth, I would still like to have some type of position where at least we could be a fly on the wall, observing or overseeing how a lot of this is done. Again, I can post on here for you if you like, and I guess here, I know I've talked about this before. I was sitting in a Tim Hortons about 2.5 years ago, maybe a little longer. Open up the first page, second page of the newspaper, little blurb about Jimmy Carter, ex-president of the United States, talking about when he was in office as president and when he was involved in negotiations with North Korea, how him and his delegation would go and converse and talk to North Korean leaders and private citizens regarding the conduct, the behavior, the future of North Korea. I was like, whoa, what did that just say? President Jimmy Carter is meeting with North Korean leaders and private citizens. I know many of you don't like the word citizen. Stick private national in there if you like. Semantics. Point is, global leaders, global government public leaders very, very much will embrace or take on or appreciate the input of the private citizens, the private nationals. Why? Because they know we're the ones that have the access to all those funds sitting on the private side of the ledger. Walter Burien, I know I've talked about this before. He's the main accountant in the United States that balances all these ledgers, all these accounts. And he came forward and he says, well, there's a whole bunch of money sitting somewhere, but yet we still have this public debt of X amount of $1 trillion every year. And he actually couldn't really, this guy's a gifted accountant. He didn't know how these funds are sitting over here and no one can access them. And yet we're all living in poverty and disparity, right? We're all living this life of slave ship. So even he was scratching his head. He's like, I don't really understand what this all is. Why is that? Because in accountant school, you want to know how much they're trained about equity. You want to know how much they're trained about, what these consolidated revenue funds are actually for. The accountants are not taught that. They're not. They're just supposed to, they're compartmentalized. Here's your job, do it like this and don't stray from that. Don't deviate. This is what you do. Next. That's all they know. They don't spend 30 years, 20 years, 10, 5, 3 months working and digging and doing all this stuff. That was our job. The accountant is not one of the meek who is meant to inherit the earth. No, that's us. Okay. The complainant charges and avers that the petitioner is I would actually say, equitable owner at this point of, or in some manner, beneficially interested in some personal chattel belonging to or of the state or province, or of some contract or agreement relating to the personal estate. What could the personal contract agreement be between you and the state? Well, enter security agreement and enter administrative agreement. If you're not interested in going forth and administrating your own account or helping your neighbor, then yes, pass that torch to the Attorney General. Build your trust as a charitable event, not for profit. As soon as you are for profit, what have you done? You've just jumped into the legal world. You're a part of that commercial construct on the shitty end. If you're profiting from stuff, how can you serve the Lord and expect to profit from it? See how that kind of doesn't work? Why do you think priests, ministers, pastors, why do you think they allegedly do this for free? They weren't supposed to be getting paid to do this. It's a conflict of interest. It doesn't work. How do you take money, dirty hand money, or wages of sin? I don't know if you've heard of that one before, but it's a thing. How do you take wages of sin and take that as compensation to serve our Creator? I've never heard of such a friggin' conflict of interest before. That is beyond, right? That's just out there. So, okay, of some contract or agreement relating to the personal estate for the rents, the profits, accruals, monies, etc. The complainant further charges and averts. Okay, so see what I'm doing here, right? I'm adding the word averts to every time we're charging something. And again, the word charge doesn't mean you're under arrest for shoplifting. That's not what charge actually totally means. Yes, that's a version of the word charge, but that's not what we're interested at this point. The word charging here, loved ones, is trying to suggest we are attaching an interest to a something. That's what a charge is. That charge literally sticks. It's there. It's there until it's discharged. And if you're the one that creates the charge, guess by default, who is the only one that can discharge it? You. Moving on. The complainant further charges and averts that the defendant, whoever that is, and where an equitable interest in chattels is obtained. How do you obtain that equitable interest in that chattel? Enter the adverse claim. There's a beautiful answer. It can be secured by a transfer of the possession or by reducing the agreement to writing. Okay, reducing the agreement. That means I had a verbal or a viva voce agreement with somebody. Now that we've established a quick verbal agreement, now I got to go pen it. Now I got to go write it down. Now I can actually say, hey, on such and such a date, this party did agree to this agreement. And that's why I can proceed. And then we want to have that agreement in writing, have it registered. Again, careful with that word registered. Registered means we're going to make it public. We're going to make it so that everybody can see it. What we are actually going to register here is the existence of our life estate. But that's it. No particulars, no who's the beneficiary, who's the trustee, how much money is involved, what the duties, obligations, that is all kept private. Nobody gets to see that. Okay, so what does the public actually get to see then? Well, they get to see a registered event of a life estate with this number attached to it. And that's it. They don't know who the parties are. Nothing can be deduced from that statement, which is why it's actually kind of safe. They can actually register it, show that publicly, but it doesn't actually harm the trust. Okay. The complainant charges and averts that the surrender or relinquishment of an existing legal right or the assumption of a new legal obligation, which is in its nature irrevocable. Again, can you imagine going from the Caesar salad, being the crouton, getting out of the bowl, experiencing this great new life? What the hell would ever possess you to now jump back in, eliminate all the good doings that you've just done and now go back to the wrongdoing? Again, unless you fall out of the turnip truck and bang your head, that is just not going to happen. That is absurd. And as a matter of fact, again, this is what part of our NDDA agreement would have done for you and others had you signed it and wanted to agree to this. If you did fall off the turnip truck and bang your head, I can literally step in and say, no. It was this gentleman or this lady's intent to never back to the legal side, right? You might have a lawyer pick up some of our paperwork and say, oh, yeah, let's get these individuals back into the public system. I could divergence or myself could literally step in and block that. Again, that was part of us acting on your behalf. This is all the NDDA is actually setting up. We're here to help. I was blown away with the amount of people that were either, scared shitless. They wanted nothing to do with it. Call me Satan. Call us losers. Call us, we're just here to steal people's estates. If that's what you want to throw at me, you know what? Go ahead. I will take that. I will transmute that energy because and I will recycle it. I'll use it for good. I know what I'm doing. I've been doing this for a long time. I know what the queens are here to do. I would not be putting myself at risk by doing everything I do daily now. If there was a chance that the FBI could show up and throw me in jail for securities fraud, not a chance. I wouldn't be doing that. Why? Because I'm very confident that what we are doing is the most honorable thing a man and woman can do. And again, if you actually read that NDDA slowly, if you actually look at the particular wording, you can see it's here to protect us a little bit, but to protect you more. It is a revocable agreement. What the hell does the word revocable mean? It means it can be canceled. Okay, so how the hell am I doing anything illegal when the agreement on the face of the agreement can be canceled? Get the picture? So again, I laugh at the turnips in the truck that always want to throw stones at us and say that we're wrongdoers and we're just, we're committing fraud, this, that, and the other. Fine. Yeah. Okay. Well, you have your opinion. I don't really give a shit. Okay. Okay. So the above is setting the stage to deal with trusts, duties, obligations, etc. So let's take a look at this for a moment. There are ordinarily 4 constituents or 4 components in any trust. Okay. Number 1, a duty to be performed. Number 2, a person or corporation expressly or impliedly charged with that duty. Call them the trustees. Number 3, a person or corporation for whose benefit the duty is to be performed. Right? Okay, so we were coming as a corporation before. That's why getting away from that corporate status was so important, setting ourselves up as the beneficiary proper. And number 4, some type of property. And again, that word property, it's very broad. It literally means everything. Everything can virtually be described as property. Corporeal or incorporeal hereditaments, which is an element of a right, liberty, means virtually everything. As far as I know, if my brain's working properly here, an incorporeal hereditament is an idea. It's something that comes from up here. I think that I am owed an obligation or duty or performance because I did this. Hey, Your Honor, what do you think? That's what the judges are there for. Okay. So some type of property, the legal title to which is vested in the trustee. There's that word vested again. Vesting. This, again, loved ones, this whole process goes freaking nowhere fast if we don't get that legal title divested out of us and vested into the new entity, the new trustees. That solemn declaration, this solemn expression is what divests, is what strips us of the liability and attaches it to the proper party. Super important. Okay. So once we vest that title in the new trustee, that enables him to effectually discharge the duty imposed on him. Here's your title. Now you can go discharge all your duties. Why? Why are you discharging? Because I charged you. So you have to have a charge and a discharge to make this thing flow properly. And all suits affecting the trust or the trust property or the trustee's rights or duties or the beneficiary's interests. Both the beneficiary and the trustee must be made parties to the action or the bill in equity or the petition that we're bringing. You got to name both. So we actually have to pick who is the trustee. And again, I can throw one out there and just suggest you what the crown is going to be the trustee. If you want to narrow that down and specifically name specific offices or holders of that office, go ahead. But again, take this for firsthand account. We had another student go into chambers, and the judge actually said to him, well, you haven't named a trustee for this particular trust, so what happened? And the gentleman's response was, well, Your Honor, this was all so rushed that it was just so frantic to get this done. Why? Because the bank just closed my account and I don't have access to anything. But all I know, Your Honor, is that no trust can fail for want of trustee. Again, use a maxim to get your ass out of any situation where you feel cornered and you don't quite know the answer and you think, well, if I say the wrong thing, this isn't going to be good. So I'm just going to use a maxim to bail my ass out. Again, get your heads wrapped around 3 to 5 maxims. If you're good at all 20, you're going to be like a shark when it comes to this stuff. So, okay, so we got the beneficiaries and the trustees both must be made a party. The trustee must be made a party first because the legal title to the property is in him. So if we're dealing with legal interest and equitable interest, whoever has the freaking legal title, that individual must be made a party to what we're doing. Kind of makes sense. And second, because it is his duty both to defend that legal title and to protect the trust and the beneficiary. Oh, like the sound of that. And the beneficiary must be made a party because in the eye of a court of equity, he or she is the real owner of the property. Here's another maxim. Equity regards the beneficial equity regards the beneficiary as the real owner. There you go. And is the person most interested in defending both the property and the trust. We can still come forward as the beneficiary or the grantor if need be. Come as the beneficiary if you need to. You can still say, hey, Your Honor, I'm not sure if the trustee is supposed to be doing it quite like that because from everything I've read from Gibson's story and Pomeroy, I'm a little bit confused. Would you mind answering this or shed a little clarity here for me, please? And again, this is what the judges are here for. As a matter of fact, I think we can bring a claim. We could bring a claim to Chambers every 6 months to have an overview done or to have an accounting done or a performance review type of an idea based on what the trustees are doing, how they're doing it, if they're doing a good job, et cetera, et cetera, et cetera. This is why we want the courts involved. The courts are here to protect us. The courts are here to protect the trustees as well. Again, this is equity at play. This is how it works. Okay, so let's just play with the creditor position for a moment. It is important to note a creditor who seeks to reach an equitable interest or estate or to enforce a lien or equitable interest of his own must make the owner of the legal title a party, as well as the owner of the equitable interest. So again, there's just more reaffirmation that we have to name both parties moving forward. Okay, nothing should be averred except what is necessary to be proved. Again, we don't need to start talking about all kinds of fluff. We've got to stick to the main points, stick to the substance of the case. If you find that your paragraphs are getting a little bit loosey-goosey, yes, use a minor fact, 1, 2, or 3 of them to set the stage to drop the major fact. Yes, okay, that's how it works. But again, the judge doesn't care about your niece who just graduated grade 12 and now she wants to go on to become a doctor. Like things that aren't really relative to the case, leave that shit out. And again, I can help you do some of this stuff because it is a little bit tougher. I know I say it right here, right now, but you know what? If I had said to all of you, okay, each of you go ahead and punch out some of your claims or some of your expressions or some of the substantial or material facts. You want to know what happens? You draw a blank all of a sudden. You kind of sit there for a moment and go, oh shit, I actually don't know. I actually got to go back and read that all again just to make sure I dial it in, get it tweaked so that I know exactly I'm focused how to write that. It takes a lot of time to be able to just have it up here where you can pull it from your brain and exercise it. Again, practice makes perfect, does it? I'm thinking perfect practice makes perfect. Okay. Would a complainant be entitled to the special relief he prays if all the averments or all the facts should be established by proof? Yes. And a test of the materiality of a particular averment is this. Can the bill or petition be fully held or fully sustained as to the special relief claimed or sought if the averment is not proved? Short answer, no. You got to state the fact, you got to prove the fact. How do you prove that you're in possession of this thing? Well, I claim to be. I mailed it to the Attorney General. There, easy. I brought it to the judge's attention for consideration so that he or she may balance the equities. These proofs, these facts are actually pretty simple once you kind of see them for what they truly are. Okay. Where, however, there is any doubt whether a particular averment is necessary, the pleader should insert it anyway. Because again, the judge, if it's a little bit too loosey-goosey, the judge will just kind of push it aside. It's better to give it to him so that he can push it aside than not put it in. We don't want to come in too light or too brief or with not enough material fact, that's actually going to put us in a shittier position than coming in with a little bit too much. Okay. So again, don't think that this means you got to crank out 40-page documents, because that's not the truth either. Okay. And it must always be remembered in drawing or creating the bill or the petition that everything which is intended to be proved must be alleged. So here you go. You're actually stating the same thing twice. I allege the sky is blue. Now I'm going to take a picture of it. Your Honor, this is my interpretation of blue, right? You got two things going on. You got to state it or allege it, create the proof, and then you're going to charge it. How do you charge something that doesn't exist? You got to make the thing exist first before you charge it. That's all that we're kind of suggesting here. So no facts are properly put in issue or brought before the court by you, the complainant, unless it's charged in the bill. And as a consequence, no proof can be offered by the complainant to any fact, however material it may be to his case, unless each such fact is stated in the bill. State the facts, then charge the facts, and then pray for relief of those facts. So actually, I'm letting the cat out of the bag here. We actually say the same shit 3 times. Why? The first time could be a mistake. Second time could be a coincidence, but the third time is true. That's why the third thing, like 3, everything's in 3s. Okay, it is a general rule that whatever is essential to the rights of you as the complainant and is necessarily within your knowledge ought to be alleged positively and with precision. What we're suggesting there is tell the court what you did or what you're doing. Don't tell the court what you haven't done and what you're not doing. That's the difference between positive averments and negative averments. I've actually done this, not I'm about to do this. See the difference? How facts must be alleged in a bill. Okay. The bill or petition should state the complainant's cause of action with accuracy and clearness. Let me just expand on this for a moment. There was a judge out of Alberta, Canada, not that long ago, who kind of publicly made this statement. Fancy language does not get the job done. Clarity does. Okay, so what that's saying is I don't need to be able to talk like Darren and Dean and some of these other people around the world that seem to just have Black's Law Dictionary in their minds, and they can just spew all these freaking words that I have no idea what they're talking about. You don't have to have that, okay? But what you have to do is clarity. You need to have clarity. And clarity is described in your choice of words that we use. Again, you don't need a PhD in rocket science to do this, but this is what the wisdom system, this is what the Divergence Live show right now is actually trying to do, is explain this and show you this. Okay, so moving forward. Specifying the rights of the complainant. And again, you don't have to have 35 pages of what your rights are. You could literally have one word, dominion. There, that covers all of it. Specifying the rights of the complainant, the injury or the grievance. If my bill is not granted, Your Honor, I will suffer this, this, and this, okay, of which he or she complains, and the relief which he asks of the court. There must be certainty in the averments or the facts that you're stating upon the bill is founded. If the title deeds, okay, or other instruments are referred to, they should not be set out in full. All that's really required is you take a couple of snippets out of it to establish only the substance of these portions is necessary to a right understanding of the real matters of the bill. So what they're saying is you don't have to include all of this. You just take this and a piece of this and stick that in your petition. If the judge needs more clarity, if the judge needs to see more evidence, he will ask you to produce it. So what this is actually doing at the end of the day is greatly shortening, it's greatly compressing, it's greatly removing a lot of the pressure from us to have this put into our first instance or our first filing. It actually makes it a little easier for us, is what that's actually trying to do. Okay, where was I? But if only such substance or those portions are necessary to a right understanding of the real matters of the bill. Again, it's just that you're going to suggest, hey, this exists because this piece exists. I have a deed of trust, Your Honor, because in paragraph 3, I've stated this. Okay, so we're just kind of shortening everything we're trying to do. Okay, so where the rule otherwise, a denial of the bill or petition would only be a denial that the complainant was so informed or so believed or was so informed and believed, neither information nor belief nor both are sufficient grounds for coming into chancery. Just because you believe you ought to come into chancery, that's not enough. Okay, just because you've got some information somewhere that you're entitled to a court of chancery, that's not enough. There must be positive facts stated, expressed, to put the machinery of the chancery court into motion. Again, if the clerk doesn't see it on the face of your pleadings, guess who's not getting into chancery today? Moving forward. By necessity for fullness and particularity in alleging or stating the facts, every fact essential to your title, to maintain your bill, and to obtain the relief must be stated in the bill. How does it even make sense that you have all these things in your mind, but if you don't put it on paper and if you don't produce it to the judge, how is he supposed to help you? Again, the judges they're kind of mind readers. They can sort of get the gist of what you're doing, but give him more than just the gist. Give him a little bit more. When the judge actually sees that you gave him a lot more reason to come to your aid and assistance, guess what he's going to do? He'll do just that. Okay. Otherwise, the bill will be fatal, for no facts are properly in issue unless they're charged in the bill. And of course, no proofs can generally be offered of the facts not in the bill, nor can relief be granted for the matters not charged. How do you expect to be granted equitable relief if your pleadings aren't equitable? Makes sense. Okay, here's some of the equitable remedies that I've always talked about. Okay, so where an injunction or a receiver is prayed for in your bill, listen, an injunction and a receiver are extraordinary processes. These aren't normal. These aren't everyday. It takes someone with a pretty good mindset and a pretty good grasp of equity, proceedings, rules, to actually get this accomplished. Now, this extraordinary process that issues before the suit is tried on its merits. Again, the judge can actually grant the injunction based on what you provide him, correct? He doesn't even have to hear a peep from the defendant. Why? Because this is the beautiful thing in equity. When you bring substance that is so strong, that is so unrebuttable, that no other man or woman, never mind a corporation, can punch holes in it, he can actually grant it. He can actually act on it right now. He can actually grant a temporary or an interim injunction just to get the crown off your back right now until the rest of the case develops and unfolds. So generally, allegations of wrongdoing or formal charges of inequitable conduct are wholly insufficient. You need to dig way deeper than that. That is not enough. That's some of the stuff that Dean and I back in the day would have tried to do. Your Honor, the crown has brought harm to me, so I need to be fixed. We need a little bit more than that. Okay, so the particulars and the circumstances must be set out so that the chancellor may see them for himself, that the doings complained of are wrong, and that the conduct charged is inequitable. For what may appear to be wrong or inequitable to you may not so appear to be to the chancellor. Besides, the chancellor prefers the facts and circumstances of the case to your opinion. Otherwise, guess what? You'd be sitting in the judge's seat, correct? Your opinions mean nothing. Do not put your opinions on anything. Do not put Your Honor, I think this and this should happen. Wrong. Do not put emotion into your pleadings. The judge doesn't give a shit about that. He knows that you're not happy. He knows that fraud is already taking place. That's why you're coming to a court in equity. Only equity can undo the fraud properly. Can you imagine creating a fraud and then playing in a fraudulent system and then actually trying to go get that fraud undone by that same fraudulent system? See how that just doesn't work? Hey, Caesar, I don't want to be a crouton. Get back in the bowl. That's all that's going to happen there. And I'm not suggesting that this crouton Caesar salad analogy is going to replace my lawnmower one. No, I'm just suggesting that, hey, that's a nice little way to paint the story for us here. Okay, so we should keep in mind here that the chancellor prefers the facts and circumstances of the case, not the opinion or the conclusions of the complainant. We should keep in mind in drawing such a bill is not only a pleading, but it is a special affidavit. Here you go. Again, these are not my words. I sucked this right out of Gibson's book, okay? I don't have a single word of mine in this from here on in. This is straight up Henry Gibson talking. So we need to be dealing with a special affidavit. That special affidavit is in the paperwork that we're providing with you. That's the one I had posted online a number of months ago. A special affidavit means it's not a general affidavit. A general affidavit is for publicans, people that are on the public side, doing public things for public purposes. We're not general public. We are private special. Big difference. Okay, so as a pleading, formal averments would be sufficient. When you do it in a special affidavit, see, no verification would even be necessary. Only a cost bond. Okay, what did that mean? No verification would be necessary. You know, when you take your affidavit and you have to go get it notarized by a notary or a commissioner and that type of thing, that's verifying your statement to be true. That's you actually volunteering to, hey, I guess I'm subject to a penalty of perjury if it's found out that I'm just completely bullshitting here. And, you know, if it's found that I'm trying to be malice, I deserve to have my ass thrown in jail. So what they're suggesting here is that when you're doing equity and seeking equity, no verification would be necessary. You don't have to have your special affidavit notarized. You don't have to have your special affidavit commissioned. It's special. It's out of their realm. They're only there for public stuff. And are we using public anything? No. So there you go. No verification would be necessary, only a cost bond. What's a cost bond? I'll actually provide an image of the cost bond I submitted to Vital Statistics 6 years ago that establishes an indemnity clause. It establishes, hey, if you need to draw any funds out of this bond to pay for court processes, process servers, decrees to be drafted, notices to be posted in the Gazette, yada, 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 yada. This is what the cost bond is for. How did I develop a cost bond? Well, this is where what value is attached to the cost bond. This is where I actually took a United States of America $10 silver certificate. I bought one on Amazon, right, for 20 bucks or whatever the hell it was back in the day. I actually had that certificate representing silver attached to my cost bond. Why do I like the silver certificate? Because it comes with a serial number. Silver coins don't. I can literally attach that serial number to any of my documents. And what have I just done? Have I not attached valuable consideration? This actually saves me the bullshit of having to attach silver coins to all kinds of stuff. Not that you had to do that, but this is where the silver certificate actually is very advantageous, okay? So here, just let me find my spot again. I always lose my spot, so just bear with me. The complainant must therefore show in his bill, show that he has such an interest in the subject matter. How do you prove you have an interest in the subject matter? This is where grantee comes in. This is where grantor comes in. I had a complete title. I'm splitting it and I'm granting half of it, or I'm granting an undivided I'm granting an undivided legal interest to the new trustees, which in exchange grants me the ability to have the equitable title or interest. And its averments, oh, wait a minute, I missed a big chunk up there. Hang on, I'm gonna go back up to the top. Okay, so this bond, this cost bond, and a subpoena to answer would issue. So when we're suggesting, hey, here's my cost bond, Attorney General, I need you to answer a couple of questions. That literally is subpoenaing him to answer these questions. And you can actually request that he does it on oath or not does it on oath. We actually have some flexibility with it, and we can talk about that another day. If all this stuff is in the special affidavit and incorporated in your petition or your bill, that the extraordinary process issues, the process won't issue if you don't have a special affidavit. The special process won't issue if you don't have a cost bond. right? The special process won't issue if you haven't expressed your interest properly. So you see how it's like we got all these freaking layers. We got all these requirements that we have to actually 10 minutes. Oh, okay, I got to find out a way to stretch time. Okay, if anyone has an idea to help me with that one, please feel free to add it in the chat. Okay, so so what this is actually just trying to say is be precise, be definite, be direct in all the circumstantial averments, and give a detailed statement of the main facts on which the injunction or receiver is prayed for. The injunction and receiver are probably the two most important things that we're going to be praying for here. And in your allegations should be on the actual knowledge of the complainant. You should actually have knowledge of this stuff. Or if on information and belief, should be verified by you. At least verify it somehow, and I'll show you how to do that. The bill must appear that it is in the first application for the particular extraordinary process prayed for. For some reason, and again, this is where when they start a process and they start attaching bond things going on in the background, believe it or not, they always want to know, is this the first instance? Is this the first time you're making application for this, or is this your 7th attempt? Because if this is your 7th attempt, you're actually telling them to go back, find the first attempt, bring it up to the table, and we actually should be dealing with it as a whole. So they actually want to know, is this your first instance? Is this your first attempt? That's actually very important. The complainant must therefore, in your bill, show that you have such an interest in the subject matter of this suit, and that as such, you are entitled to the aid of the court to the protection or enforcement of that interest. Again, see, we're actually developing some layers here. We're actually talking about some specifics. We're laying out some facts, material evidence to the end. In tendering consideration whereof, or, hey, I'm presenting to the court, or I'm presenting to your honor in chambers. Tender, I'm actually tendering something, okay? And for as much your petitioner is remediless in law. Why are you remediless? Let's just go over that for a quick second. When you take all your legal rights, you attach it to a birth certificate, you fire it off to a new trustee, how much legal remedy do you have now? Here's a hint. That much. Because you just got rid of your legal anything you had. You don't have the ability to exercise any kind of legal anything. And this is where we get caught, or this is where we get busted. Okay, I've granted the legal thing away, and then I go on over here and I start talking about wanting legal relief, legal remedy, legal compensation for damages. Wrong, wrong, wrong. Once you grant that legal shit away, do not start talking about it again. Now, we talk about it briefly in order to grant it away, but that's it. We never go back to it again after that. This is where the Attorney General, if you're not quite competent enough to act as administrator for your own affairs, he will do it for you. This is one of his primary jobs. Again, believe it or not, we as concerned private nationals or private citizens, we can bring a claim for Her Majesty, or we can bring a claim against Her Majesty. The Attorney General will jump in. If you're bringing a claim for Her Majesty, the Attorney General literally grabs it and uses it for you. He actually acts for you. He actually literally becomes your lawyer. At the end of the day, that's what's going on. You got the best Top Gun lawyer in your province, your state, whatever, actually working for you, administrating your trust in the background. Here you want to talk about being special? Who's your lawyer? Oh, the Attorney General. Who now has the ability to bring a claim against your trust or against your life estate. Every claim must be brought through the Attorney General's office, correct? How can a third party bring a claim against your trust through the Attorney General? See how the Attorney General is going to catch it? He's going to say, oh, no, you can't do that. Action dismissed, and bounce it. That's the job. That's the duty. That's the obligation that the Attorney General has. Again, this is where I'm a big proponent of being respectful, coming in with some class, coming in with some dignity. Dean and I have sent letters to the Attorney General in the past, and I can tell you right now, Dean was calling the guy a fucking asshole. So now we're actually going to turn around and ask the guy to administrate our estate for us. So you see, for me anyway, I kind of feel a little bit that big. It's like, I wish I didn't call that guy a fucking asshole, because now the guy's got to be my best friend. See how, again, we didn't know back in the day. We were pissed off. I remember, some of the these belligerent free men on the land guys that are going around making a mess of everything. Okay, I understand why they did that to us. I understand, right? It actually makes sense. Why? Because we were acting like assholes. And we actually deserve getting bounced out of court. We deserved getting thrown into solitary confinement for a week or 3, right? Again, based on our own actions. Let's come with equity. Let's not come with hate. We're going to get to the finish line. We're going to have access to the rainbow here much quicker. Okay, so the petitioner is remedialess in the premises that we've mentioned above, at and by the direct and strict rules of the common law, and cannot have adequate relief except or save only in a court of equity, where matters of this and similar nature are properly cognizable and properly relievable. Take care, everybody.